Hello friends, this is PP and welcome to Law for All. In this video, we're going to be learning about how to draft an agreement for sale. Now, an agreement for sale is governed under by the Indian Contract Act, whereas a sale deed is governed by the Transfer Property Act. An agreement to sale is essentially an agreement as that of any other agreement, except that it is an agreement to sell a specific plot or a property or anything. It can be either a movable or an immovable asset. So, therefore, an agreement to sell is only an agreement and it is not actually a transaction of sale. Now, before I proceed into this video, I would like to point out that if you're interested in learning about various subjects under the Indian law, then I've left some useful tips and I've left some useful links in the description section of this video, so you can kindly check that out if interested. Now, proceeding further, an agreement for sale, as I pointed out, is only an agreement to sell something and not actually a transaction of sale. So, therefore, if an agreement for sale of plots, say, is executed, even the possession is granted to the prospective purchaser, it would not create any sort of a vested right in the purchaser, because there would not be any specific transfer of right. It would only be an agreement for sale of that specific plot. Now, an agreement for sale is required to be registered. It is not essentially required to be registered under the Indian Registration Act, but an agreement for sale requires the stamp duty to be paid as per the Indian Stamp Act. So registration is required for those documents which only create or purport to create a right or any interest in the subject matter of the property in the third person. So if the document is of such nature, only then is it required to be registered, not otherwise. So therefore an agreement for sale, as I pointed out previously, does not create any right in the third party, and so therefore an agreement for sale is not required to be registered before the sub-registrar under the Indian Registration Act. Now, I have also prepared a demo agreement for sale as always, and I will be turning to that demo now, and I will show it to you guys. Now, this is the demo of the agreement for sale that I've prepared. Now, let us get into the agreement and try and understand how the agreement is drafted. Now, this is the general format. This agreement for sale is made at so and so on this so and so date. That is, you have to state the place and the date on which the agreement is made. That would be the first recital. Then afterwards you have to state the name of the parties. Now, as always in every legal document or conveyance, you have to describe the party or the person as much as you possibly can. That is, the party's name is required to be stated, the name of the father, the age, the marital status, the employment status, the residential status, and all of that would have to be mentioned so that the person can specifically be identified. Now, if the document is to be registered before the sub-registrar, then sub-registrars also insist upon stating the PAN card number and the email addresses, the mobile number, what have you. As many details as you can possibly give them, so that the person can distinctly be identified. So therefore that is something that you have to keep in mind. Now, the person who is purporting to sell a plot or an immovable property to a third person is always referred to as a prospective vendor. That is, a person is not actually selling something through an agreement for sale. As I pointed out earlier, an agreement for sale does not create any right in the third party. An agreement for sale is only an agreement to sell something in the future. So therefore, the person who is purporting to sell a property to a third party is always to be referred to as the prospective vendor, and the person who is buying the property or who is interested in buying the property is to be referred to as the prospective purchaser. Now, this term right here, that is the prospective vendor or the prospective purchaser, as the case may be, can be anything. It is not necessary that it has to be stated in this specific fashion only, that these specific words are required to be used. You can use any sort of phrases you like, so long as they make sense and they fit into the context. Like, for example, the first party, the second party, you know, and the transferor, the transferee. You can use such terms also, so long as they make sense and so long as they fit into the context of the document. And now subsequently what you have to take care of is this phrase right here that I've highlighted, that is, which expression, unless repugnant to the context or meaning thereof, shall include his heirs, executors, administrators, and assigns. Now this phrase essentially means that if in the event subsequently, after the agreement is executed, that the prospective vendor or the prospective purchaser, as the case may be, expires, then the legal heirs of that said person come into the picture. And so therefore this phrase covers that aspect of legal heirs coming into the picture. That is, this phrase provides that the prospective vendor shall also include his heads and executors and administrators and assigns if in the event the prospective vendor is personally not present, or if he expires, or if he transfers his right or interest to any third person. Now same applies to the prospective purchaser also. This clause can be individually placed, or otherwise a specific clause can also be placed which will apply to all the parties in an agreement, and that is generally convenient if there are many parties in an agreement. Now proceeding further, in this specific agreement, the vendor number one was represented by his duly constituted power of attorney. So if in case if any party is represented by their power of attorney, then it is required to be stated in this fashion. Instead of stating it here altogether, it can be stated in this fashion so that it becomes a little more convenient. Then proceeding further, these are something known as the recitals. In an agreement, there is something called as a recital and there is something called as a covenant. Now, covenant is something that I'll get to later, but I will first explain the recitals. Now, a recital essentially means an introduction. In an agreement, the flow of title will have to be explained, the property will have to be explained, and how the property came to be about, what the property constitutes and what it forms a part of will have to be explained. That is how the title of the property can clearly be made out, and it becomes easier for both parties to understand and interpret. Even in the event if the property is to be subsequently sold to some third parties, it becomes easier. So this is called essentially a recital in an agreement. So therefore in a recital, as I pointed out, you explain the story as to how the vendor became the owner of the property and how the purchaser came to meet the vendor and how the transaction was struck. So this is essentially a recital, and this is how it is always drafted. It always starts with whereas there exists a property admitting an area of about so and so, and in the latter paragraphs it is always and whereas. That is, you have to end whereas, that is, it is sort of a continuation to this whereas, except that this is a separate paragraph. So you have to keep on adding and whereas to all subsequent paragraphs, and that is how you have to draft paragraphs. Now finally, uh, you have to state as to, this is a standard clause which is always stated, uh, that is, and whereas the prospective vendor is agreed to sell to the prospective purchaser, and the prospective purchaser agreed to purchase the said property for a total consideration of rupees so and so. So you have to state the amount for which the agreement of sale is to be struck. Furthermore, you have to also state the for the purpose of payment of stamp duty. If in the event you're registering the agreement for sale, then you have to state as to how much the property is valued for, because the state, then accordingly stamp duty is required to be paid. So this is also an so this also is an important clause, uh, and so yes, so this clause also will have to be included in that fashion. Now another thing to keep in mind specifically is the fact that you have to sort of state this part here, that is a property that is to be sold, either it may be the largest property, the smaller property, the property will always have to be described in a schedule. That is, for example, you every property, uh, there has to be one specific phrase which one can use to refer to the entire property. Otherwise, it becomes inconvenient for the parties to keep on explaining, or the draftsman to keep on explaining the boundaries and the details of the property. Sometimes it so happens that there are many properties, and so therefore it becomes a little difficult to explain those properties. So therefore, what is required to be done is, multiple properties are sort of are there, so therefore specific words are to be used. So therefore, as in this case, the word schedule is used, that is the said property. So therefore, as in this case, this there is a specific schedule as regards the property, and so therefore the property shall always be referred to as the said property, and the entire property shall be described in the schedule of the property. So this is how one of the drafting, this is one of the drafting conventions, which you have to also take into consider, and which has to be kept in mind accordingly. Now also you have to state that this clause right here, that is, now this agreement of sale witnesseth as follows, that is, once this statement is made, whatever proceeds afterwards is the covenants that I was referring to previously. Now we've been, all this while we've been dealing with the recitals of the agreement for sale, and now we are going to deal with the covenants, that is specific conditions in the agreement for sale, whatever that has been agreed upon between the prospective vendor as well as the prospective seller, prospective purchaser, sorry. So now in this, now these are the covenants, that is, I'll just read out a few. The prospective vendor hereby acknowledges, accepts, admits the receipt of sum of rupees so and so paid by the prospective purchaser to the prospective vendor today, that is, on the execution of this agreement, as part payment by cash. That is, if in the event any part payment is made, then it is required to be stated specifically, and the receipt of that amount is required to be specifically acknowledged by the opposite party as well, so that there is no confusion subsequently. So it is required to be stated in this fashion. If in case no part payment is made, then there is no issue, because the thing is that for a contract to be valid, as you guys already know, under the Indian Contracts Act, every contract has to have a consideration. Every promise made has to be for a consideration which is either paid, promised, partly paid, or partly promised. So therefore, if a contract does not have a consideration, then the contract does not become valid in the eyes of law. So that is one factor that has to be kept in mind. Every contract has to have a specific consideration, without which the contract does not become valid. So that is another thing that has to be, as I've pointed out, uh, has to be kept in mind. So therefore, if part payment is made, then it is required to be specifically made a mention of in the covenants of the agreement. Now proceeding further, second covenant, that is, the prospective vendor hereby agrees to sell, transfer, convey, and assign all his rights to the said property in favor of the prospective purchaser, and the deed of sale shall be executed within a period of so and so months from the date of execution of this deed. Now, the date period within which the agreement is to be completed is also required to be stated in the agreement. Otherwise, the agreement always remains in a lingo, because the parties have to know as to when the agreement would finally crystallize. So, therefore, it is always safe practice to state as to within what period the agreement is to be completed, unless otherwise the parties explicitly agree that they do not want any time limit for the said agreement. Now, proceeding further, uh, the prospective purchaser shall pay the remaining amount of rupees so and so on the day of the execution of the deed of sale. That is generally the convention that is followed. The remaining balance consideration of a document is always paid at when the document crystallizes. This covenant also is something worth taking note of. That is, the prospective purchaser shall have a right of specific performance of this agreement in case the prospective vendor fails or refuses to execute the deed of sale. Now, this covenant is not required to be stated necessarily, because irrespective of whether this covenant is stated or not, as per the Specific Relief Act, the person, whoever, either of the parties will have a right of specific performance. So therefore, irrespective of whether this statement is made or not, the party will always have a right of specific performance. Such clauses, like the prospective vendor does hereby confirm that the prospective vendor is the only owner of said property, and that it is free from any encumbrances and there are no claims whatsoever, is also sort of an indemnifying clause. That is, it is meant to protect the purchaser, prospective purchaser. So this is also one of the important clauses. Furthermore, there is this is sort of a non force majeure clause. That is, it states that if in the event the prospective vendor hereby agrees that the said property could not be conveyed in favor of the prospective purchaser, or if the deed of sale could not be registered due to the defect in title of the prospective vendor, they shall refund all the money received from the prospective purchaser with a compound interest of 11%. So, therefore, if in the event a deed of sale is not executed, then the part payment made by the prospective purchaser is stuck with the prospective vendor. So, therefore, since it is stuck, if in the event the document cannot be made, then the amount is to be returned with compound interest of 11%. This is an optional covenant. Some do put it, some do not. So that is something also that can be considered. And then finally the schedule is to be stated at the end. Now this is the system, this is the format of stating a schedule in an agreement for sale. It is the same as that of how it is stated in a sale deed as well. So you guys, if you want to go through it, then you can pause the video and go through the content. By the way, you can pause the any part of the video and then go through the draft that I've already prepared, and you will get an understanding of how the agreement is to be drafted. Finally, this is a standard clause, standard statement that is made in the agreement, and then this is followed by the signatures of the parties and thumb impressions, if any. Also, something that is to be kept in mind is an agreement requires being attested by two competent witnesses. So that is necessary, even if it is not registered, even if it is not notarized, the agreement for sale requires it to be attested by two competent witnesses, without which the agreement is not complete. So you have to make sure that the agreement is always attested by two competent witnesses. Now that is it. That is all that I have for you in this video. I hope you have learned something, and I hope that I've been able to help you. If you like this video, kindly do give it a big thumbs up. Kindly share the video with your friends if they might be interested, and subscribe to this channel for more such content. Thank you for watching.